Hi, and welcome back to the Educational Leadership Exchange podcast. I'm your host, Kristen Schmidt, and you're listening to part 2 of our episode on education law with Justice Marvin Zucker. Justice Marvin Zucker is an associate professor of education law at OISE in the University of Toronto, as well as a practicing judge in Ontario. This podcast is produced by the Canadian Principal Learning Network Leadership Unit. In part 1 of Educational Leadership Exchange, we discussed bullying and the law. If you haven't had a chance to hear that one yet, I encourage you to do so. No worries though if you haven't, because this part, although an extension of the last one, does not reference the same topics as covered in part 1. This part is all about the duty to report to the Children's Aid Society and protecting children from child abuse. Welcome to Educational Leadership Exchange.
There's no such a thing as confidentiality, but you have no obligation. In fact, if there's a risk of harm to the child, you would have an obligation to report, never mind anything else.
Before the school year started here in Ontario, the Ontario College of Teachers sent out an important professional advisory about the teacher's duty to report child abuse to the Children's Aid Society, or CAS for short. I received my copy not too long before my interview with Justice Zucker, and so I asked him to clarify what the duty to report really means. It turns out he was actually an advising author on that very document. So in the following clip, Justice Zucker will share some crucial information that anyone working with children has a professional duty to know about.
Click on section 72, and that's the section about duty to report. And the duty to report is mandatory. It's not discretionary, and it's mandatory by the teacher, not the principal. It's something that the teacher must do on their own. In terms of a disclosure made by a child to a teacher, or if the child makes a specific disclosure to a principal, then of course the principal would call the Children's Aid. But normally what happens is the child would, and I'm talking about children because we're dealing with those under 16. If you're over 16 and there's a disclosure made about being abused, then in my opinion, without hesitation, because the Children's Aid will not get involved, the principal should call the police. And in fact, in my opinion, again, I'm not supposed to give opinions being a judge, but in my respectful whatever, if you're under 16, I would not only call, I would first, I'm required to the duty to report under section 72, despite the provisions of any other act, if a person, including a person who performs professional or official duties with respect to children, has reasonable grounds to suspect. You don't. All you have to do, the ground. Yes, professional duties means a teacher, and means other groups. If you look at 72 subsection 5. Every person who performs professional official duties with respect to children, including a healthcare professional, doctor, nurse, dentist, pharmacist, be a teacher, school principal, social worker, family counselor, operator. So it's a teacher. It doesn't matter where you're a teacher. If you're a teacher of children, if you're with children, if you're a daycare provider, day nursery, you work at a day nursery, if you're a religious official, if you're a priest, a rabbi, member of a clergy, you have a duty to report.
The point Justice Zucker makes about every person's responsibility to report is crucial. It makes me wonder how common it is for others who care for children to know about this duty to report, like daycare workers or anyone else, really. Do they know about it? Do they know it's their duty? At least as teachers, we have a lot of professional development about this type of thing. It also makes me think of a recent court case that's been news in Ontario now. It's about a boy whose parents abused him physically with violence. The person to report the first instance of abuse was actually the boy's friend's mother. He was actually over at a friend's house when the friend's mother noticed bruising and asked him about it. It really drives home the point anyone who works with children or is in the care of children has a duty to report to the Children's Aid Society. As educators, we know that this is something we need to keep in mind at all times. I remember doing some professional development on child abuse, and a colleague of mine asked, well, what if the child makes us promise? Like, what do I do then? How can I be a confidant and earn their trust? Well, knowing full well I need to essentially tell on them to the Child's Aid Society. What do I do? So here's Justice Zucker addressing this very issue.
If it reasonable suspicion simply means that the child has disclosed to me, that's all. You are not the person to decide whether the 5-year-old or 15-year-old is telling the truth. That's not your job. There's no such a thing as confidentiality in an education context. So a child may disclose something to you that he or she may believe that you may keep confidential. But you have no obligation. In fact, if there's a risk of harm to the child, you would have an obligation to report, never mind anything else. So there's no confidentiality. There is the Municipal Freedom Information Protection and Privacy Act, and we may not have enough time to get into that in terms of personal information. And again, principals can look at that legislation. When am I entitled to provide any information about a student of mine to third parties? Somebody might request. There have been cases where a teacher a teacher is charged with abusing 5 students. So in one case, this goes back to 1995. This particular case where the lawyer for the accused teacher wanted the personal information, the OSRs of every one of those number of students who said that this teacher abused me. And the judge said, you're not entitled to the information. You can get enough information. Now, hypothetically, if a parent chooses to consent to provide that information, that's another thing. If a child or a young person is under 18 and living at home, the disclosure, the consent is up to the parent. If you are 18 or older and you're in high school, then theoretically or legally, the disclosure is up to you, not your parent. The other thing which is very interesting is there are cases where children choose to live on their own. And the courts have said if a child chooses to live, somebody who chooses to live on their own, the parent, for example, are not entitled to know where they're living.
So I mentioned at the top of the episode about the professional advisory put out by the Ontario College of Teachers, or OCT for short. You might hear Justice Zucker or I refer to the Ontario College of Teachers again, and that acronym is OCT. You can actually get this advisory by going to oct.ca. OCT.ca is actually a really great website full of awesome resources. You can actually look up any Ontario certified teacher there, even me, if you're curious. My name is Kristen Schmidt, by the way. Anyway, the advisory on the duty to report is essentially a 4-page document of up-to-date information all educators should know. It's a quick read and it's so important, so I definitely encourage you to go check it out. So in the following clip, Justice Zucker talks a little bit about that specific advisory, but then he also mentions important things to do when you know a child is being abused.
We talked briefly about the new advisory, professional advisory, and I think that principals should try to make sure as much as possible that the teachers go to the Ontario College of Teachers website, oct.ca website, and look at the professional advisories, because it's important. You know, ignorance of the law is no excuse. Ignorance of the advisories is no excuse. They're there for a person. They're there to help teachers, but also to protect children, because that's what it's all about, the protection of children. So clearly, Section 72 of the Child and Family Services Act mandates when you suspect that a child is in need of protection, and you'll call the Children's Aid Society. And certainly if it's at the end of the school day, a child makes a disclosure, you don't send the child home. Because you're sending the child home to the same environment. If it's a situation where the abuse might be as a result of a teacher physically or sexually abusing a pupil, then under Section 43, if I recall correctly, the Ontario College of Teachers Act, then there's a duty not only to suspend the teacher or remove the teacher from the classroom, but also report to the College of Teachers, where any teacher has been removed with respect to any negative behavior involving a student. And it doesn't have to be physical, it can be on the internet, it can be bullying, it can be cyberbullying, it can be invitation to have a relationship or whatever, or the expression that courts have often used is grooming the young person,
Thank you so much for listening to part 2 of our interview with Justice Zucker. If you're interested in listening to part 1 because you missed it, that's on education and bullying and the law, which is also an extremely important topic. If you're interested in just raw clips of Justice Zucker talking or more information that I wasn't able to put into the episode, you can of course find that on our YouTube channel. Our YouTube channel is called the Canadian Principal Learning Network, and our podcast is Educational Leadership Exchange. Thank you again so much for joining us, and please feel free to send us an email, share your thoughts with us, let us know what you want to learn about, what you're curious about, questions or comments you had. We want to know it all. So you can email us at cpln@cpln.info. Thanks again. Have a great week. This podcast is produced by me, Kristen Schmidt, as well as by CPLN's Leadership Unit and Dr. Stephanie Chitpin at the University of Ottawa.